This time we'll call to order the special meeting of September 1st, 2022. Councilmember Perez, will you please lead us in the Pledge of Allegiance? We'll now a roll call, please.
Councilmember Perez. Councilmember Resendez.
He has open house tonight.
Councilmember Morales. Councilmember Burns
Here.
and Mayor Velazquez.
Here.
And the agenda for the City Council of the City of Hollister Special City Council and Special Joint City Council and Planning Commission of September 21st, 2022 was posted on the bulletin board at City Hall on August 30th at 5:30 p.m. per Government Code 54956.
Thank you. We'll now move to item A1.
Barney, do you want to handle this one or you want me to?
Your choice.
I just real quick. So this is to item to correct a clerical error for one of the ballot measures, and we're just asking you to approve that correction so that that the ballot measure appears correct.
Can you please explain so everyone knows what's the issue?
Bonnie, you remember? Okay, now I'll turn back over to Bonnie.
There was a typo for one of the government code sections, the one that's being added by the ordinance. If it passes, it should be 204.340, and it was written as 0.300. Just a one letter typo, but the county registrar has asked us to correct it formally.
Okay, is there any questions? Do we have any comment cards? Okay, I actually voted no on this whole item, so I want to make sure where are we at if I vote no on this item again here? Is there a majority? The two constitute a majority?
Yes.
Yeah, right.
Yeah.
So, thank you.
So, so this is Mary, and I caught the tail end of the question, Mayor. Can you hear me okay?
Yes, we can. Thank you.
Okay, so for purposes of a resolution, it has to be 3-0.
Okay, well, the problem,
I understand the problem. I understand the problem. But the government code is clear. For purposes of resolutions, it has to be 3-0.
thank you. But Ms. Burns, go ahead.
Thank you, Mayor. So can we continue the item until after the presentation if there's a possibility that one of the other council members, or can we just pull it and bring it back to Monday? Or I'm sorry, pull it and bring it back to Tuesday? And what would that vote require?
There was some sense of urgency from the registrar because they're in the process of getting the ballots printed.
No, I understand,
Yeah.
but it's tomorrow's Friday
Right.
and nobody's working on Monday. And we have a council meeting on Tuesday, so.
I think this is the item, but we'd have to vote on it. So is there a motion?
So moved.
The motion, is there a second?
Second,
Motion second, all in favor?
yes.
Aye.
I'm against. Can't see myself voting for something I voted against, so.
Could I,
So Bonnie, I'll work with you and the attorney Jim Priest on a correction through the clerk's office.
okay,
I'm sure there's a way to get that fixed. So I don't want to contradict myself.
No, I appreciate that, although at the end of the day, I mean, it's my sense it's already been approved to go forward. So either goes forward correctly or goes forward with an
Incorrectly.
error.
I think Mary, as you point out, there's a way to correct it.
Yeah, if we can't correct the clerical error, it will go forward with the incorrect codification, and we'll have to fix it at a later date, is what I understand. But I'll work with Attorney Jim Priest.
Thank you. All right, is there a motion to adjourn the special council meeting? There's a motion, is there a second?
Question, does this also require a 3-0 vote?
I don't know.
So to adjourn meetings, and no, there's nothing in the government code that says it requires a 3-0 vote, but it's more procedural than anything else, nothing substantive.
You can stay here all night if you want.
All day tomorrow too. So as I recall, there's a motion and
Is there a second?
second,
Motion second, all in favor? Aye,
yes.
motion carries. Okay, now we'll bring up the planning commission members.
Testing.
Hey, buddy. Looks like a congressional panel or something. All we're missing are the photographers running around. Part of this. All right, this time we're going to call to order the special joint meeting of the City Council and Planning Commission of September 1st, 2022. Roll call, please.
Mayor Velazquez,
Here.
Councilmember Perez.
Here.
Councilmember Resendez is absent. Councilmember Morales is absent. Councilmember Burns,
Here,
Planning Commissioner Dubois,
Here.
Planning Commissioner Stevens, absent. Planning Commissioner Henderson
Here.
and Planning Commissioner Corona.
Here.
Thank you. We'll now move to item B1. And if you can, every time you guys speak, if you can use your names first, because you don't have name tags there for the public, so they know. Your mic's on.
Good evening, Mayor, City Council, and Planning Commissioners. I've met all of you, but for the sake of the public, I'll introduce myself. I'm Jennifer Thompson. I'm an attorney with Lozano Smith and the Assistant City Attorney for the City of Hollister. And then, as you heard, we also have with us remotely Mary Lerner, who's also an attorney with Lozano Smith and the city attorney. So tonight I'm going to present some very high level information about board governance and planning and development law. And the purpose of this presentation is really just to provide both bodies, the city council and the planning commission, information that's going to help you make legally defensible planning and development law decisions. And can you hear me okay this far away from the microphone? Okay. This is me and Mary. All right, so.
Could you bring the mic a little closer
Oh,
to?
sure, yeah, that's what I was afraid of.
Move to the side around the computer.
Oh, there we go. How's that? Better?
That's better. Thank you.
Okay, great. So this slide shows a roadmap of our presentation or my presentation tonight. As I mentioned, I'm going to be discussing some board governance issues. So the Brown Act, Rosenberg's Rules of Order, and some council rules that have been adopted in the municipal code. The California Public Records Act, which we typically refer to as the CPRA. And then I'm also going to be discussing some planning and development law, which is going to include a land use 101 section, a discussion on the roles and responsibilities of different parties at the city as they relate to planning and development, and then some legal issues that are specific to planning and development. So the Brown Act, which you're all probably relatively familiar with, is the Ralph M. Brown Act. It's a California open meeting law for local agencies. And you can find it in the government code starting at section 54950. If you haven't already received this handbook, I do have some extras here for you, so see me after. But today's presentation is intended to be a high-level overview, and this handbook will provide more information than I'm going to provide tonight. The Brown Act is a sunshine law, which means that it's intended to shine light on local agency business. So local agencies like the city of Hollister are required to conduct all of their business in public so that your constituents can see what you're doing and have an opportunity to comment on that. I see what's happening there. Where's the rest of my slide? Okay.
Now, did they violate the Brown Act by not bringing us copies and
No.
If there's four of them that find this together.
I'll be talking to staff later.
So in general, the Brown Act requires these things that are on that slide. It requires that actions and deliberations be taken in openly and in public, that meetings are held in public unless a closed session is specifically allowed by law, that meeting agendas and board packets are posted in a place that's freely accessible to the public and on the city's website, and that members of the public are permitted to comment on board business. And just as a side note, throughout this presentation, I'm going to refer to both of your boards as boards. So both the commission and the council, just for kind of ease of discussion, I'll call you the board. All right. So what is a meeting under the Brown Act? Essentially, it's a congregation of a majority of the members of the board at the same time and place to hear, discuss, and deliberate an item within the body's jurisdiction. And the basic rules is that the Brown Act applies whenever a majority of the board meets. So a meeting can really occur even if the board isn't taking action or a concurrence isn't being reached on a topic. It's just when a majority of the board meets, that is a meeting. Under the Brown Act, all meetings must be open to the public unless authorized for closed session. And specific reasons you can have closed session are in this book here. So the default rule is basically that meetings are always open. So we've talked about what is a meeting. Now let's talk about what isn't a meeting. So the first thing to be aware of is that individual contact with your constituents or conversations with someone like the city manager one-on-one are not meetings. It's expected that board members will talk with their constituents and it's expected. So if you run into one of your citizens in Safeway and you want to chat with them, that's fine. Or you want to meet with a group of constituents, at a coffee shop, that's also fine. Another example or question that we get is related to community meetings. So if the majority of the board is interested in attending something like the meetings that PG&E holds to discuss power outages or fire safety issues, the majority of any one of your boards could attend a meeting like that. The same goes for something like a conference, like the League of California Cities Conference. It's occurring next week. If a majority of one or both of your boards wanted to attend something like that, that would also be permitted. The key is that when you are in attendance at one of those meetings, you're not discussing board business.
I think also I'm gonna jump in here and add one other thought, is this idea of perception. So if you were attending one of those meetings, for example, the league conference is coming up next week, and we're all sitting together, a majority of council members, and then a majority of council members are standing around talking, it could give the perception that you're discussing city business, not necessarily what you had for breakfast or where you're going to go for dinner, things of that nature. So something just to keep in mind, it's not a Brown Act violation, but there is public perception that we recommend you take into account as well. And then I also want to add one other point about what constitutes a meeting. So, and your handbook goes into this in much greater detail, but this idea of hub and spoke communications or chain link communications. So it would still be considered a Brown Act violation if, oh, okay. All right. I'll stop there, Jennifer.
But you don't have
Go
to
ahead.
stop. I just wanted the slide to support what you were saying.
Okay. All right. Yeah. So if A talks to B about, do we want cannabis in our city? And A says, I don't want it in our city. And B says, I don't want it in our city either. And then they go to C and B goes to C and C says, well, I don't want it in our city either. Then what information does B have? He knows how two other people are going to vote, most likely, and it will be in alignment with how he views cannabis. So you need to be careful about those chain link meetings. You also need to be careful about the hub and spoke. So while it's okay to meet with Brett shouldn't be sharing with each other council member conversations that he's had with one on particular their views about something. So if a council member meets with Brett and says, you know what, Brett, I'm really not in favor of cannabis coming in here. And then Brett meets with the next council member and says, well, you know, so-and-so is not in favor of cannabis coming in here. And that person says, well, I'm not in favor of it either. And you can see how the hub and spoke will work from there as well. So those also constitute serial meetings, and they are prohibited by the Brown Act as well. Okay, Jennifer, go ahead and take it back.
All right. So the bottom line is that, like the slide says, the majority of members cannot discuss issues outside of a meeting. So that's really kind of the bottom line when it comes to what is a meeting under the Brown Act. So moving on, actually, there's one point I'm going to jump back a little bit. There was one point I wanted to make related to technology. So serial meetings can also occur via technology. You know, whether you're texting or emailing. And so it's just important to keep in mind that when you are texting and emailing on your personal devices, so it's kind of it makes sense, and given that when you're texting and emailing from a city issued device or city issued email, that those would be, and I'm getting ahead of myself, starting to talk about the CPRA, but I'll just skip ahead. My apologies. Okay. Yes.
Jennifer, if we have
Yeah.
questions, do you want us to hold them or ask as you go?
No, you can ask as you go or
Okay.
as I go.
So I just want to clarify. So the Brown Act applies to the council and all commissioners or committees as well?
Yeah.
Okay.
So
And so I'm going to throw a little what if at you, and hopefully I won't take it beyond that. So what if my commissioner, District 4 Commissioner Luke, and I are having a conversation and David comes together? Is that a violation if we're talking something about a planning issue?
So the three of you
The
planning
three of us?
commissioners,
No,
Yeah, so I'm going to jump in here. No, two separate bodies, council member. Two
okay,
separate bodies. It's specific to your body. One thing I am going to point out, though, you brought up the fact that, okay, commissions, committees subject to the Brown Act, ad hoc committees are not, because that is by rule less than a quorum of council members or board members, commissioners. You just want to be mindful that when you start sharing those thoughts and opinions with single colleagues, that you could create a Brown Act violation, a meeting violation scenario.
Thank you.
All right, so I'm going to move on to another tenet of the Brown Act, which is the agenda. So there are certain things that are required to be on the agenda. And first you have to have a brief description of the item that's going to be discussed. And that description needs to be in unambiguous language so that the public is aware of exactly what business is being conducted at the meeting. The agenda also needs to include the time and location of the meeting. So people need to know where to show up if they want to comment. In addition, the agenda does need to be posted. I think I mentioned this a little bit earlier, in a location that's freely accessible to the public and on the city website. And so freely accessible to the public means that someone has to be able to walk up to a bulletin board or some physical location and read the agenda, and it needs to be available for the entire posting period. So that means that it can't be locked inside of the city hall lobby, because at midnight, the day before the meeting, someone wouldn't be able to walk in and read the agenda. And then again, it's on the city website, but that doesn't fully satisfy the freely accessible requirement, because even today, some people still don't have computers or internet access. So that's why we post it also in a physical location. And then in addition, it does need to be available in other formats, ADA compliant format. So for example, large print, if someone needs that format for an agenda. Yeah, actually.
It doesn't have to be posted in Braille.
No, it doesn't have to be
Well, in the
posted in
future.
Braille. Yeah, I'm not 100% familiar with what ADA requirements are, what those requirements are, but I know that upon request, we would definitely look into what someone might need. All right, so speaking of the agenda is essentially the game plan for the board meeting. And so the rule is that the board can't discuss anything that's not on the agenda. There are some exceptions to that, but they do arise pretty rarely. And those exceptions are emergency situations, something that's called a subsequent need item, or a held over item from an earlier meeting. And so an emergency situation is really applies to pretty serious and significant health and safety issues. So the examples that we give are a terrorist act or a mass destruction, a crippling disaster. So these are really serious situations. And if the board wants to act on an item that's not on the agenda in an emergency situation like that, they do have to vote prior to taking action on that item that there is in fact an emergency. So a majority of the board has to vote, yes, we determine there is an emergency situation, and then they can act on an emergency item not on the agenda. A subsequent need item is similar, but different. So this is something that arises after the agenda is posted, but the board determines still needs immediate action. And that requires that there's first a 2/3 vote of the board before you can take action on that item that's not on the agenda. So it has to be something that arose after the agenda was posted. You decide that it really does need to be decided now. And then before you take action on that item, the board has to vote by 2/3 vote, more than a majority, that needs to occur. And then
it can't be, I do want to stress on the subsequent need item, it cannot be something that, oops, we forgot to put it on the agenda, or, well, I knew about it, Friday morning, but it didn't make it on by Friday afternoon. That's not going to be sufficient either. It really needs to be sort of an urgent need, not the threshold of emergency situation, but something that needs urgent attention.
Yeah. And then the last type of item that you can bring or decide on that's not on the agenda is something called a held over item. And this isn't something that's likely to occur often. And essentially what it is there's an item that appeared on a previous agenda that was a posted agenda item at a previous meeting. That meeting was less than 5 calendar days before the current meeting, and that's the part where it seems pretty unlikely to occur. And also the item has been continued to the current meeting. And so a lot of times when you're continuing items, it's ending up on the next agenda. So this isn't that situation. This is a situation where that continued item somehow didn't end up on that next agenda. That distinction makes sense. Sorry, it's a little challenging doing both. All right, so another thing I would like to stress is that your board meetings are a meeting of the board in public. They're not public meetings. And the reason that we make that distinction is because the purpose, it's important to remember that the purpose of your board meetings is to conduct board business. And so you're able to set criteria for your own meetings. For instance, you set the reasonable time limits on public comment. Both boards currently use 3 minutes. You also have the right to control disruptions that occur during your meetings. And you have the authority to adjourn a meeting or to continue items to later meetings, which I've seen you do.
And I want to stress one thing here too as well. So if we end up in a litigation scenario, the minutes are what is considered our official record of the meeting. And so when and if members of the public are allowed to speak just from their seats, we may not be capturing what they're saying, or when multiple people are speaking at the same time, it's going to be difficult to capture what's being said for our minute purposes. And that's why we encourage people to use the lectern, the podium, and speak during their actual allotted time periods, because we need to help our clerk in capturing what's being said. Thank you.
So just a little bit on public participation to just go off of what Mary was saying. The Brown Act is clear that you do need to require or allow time to provide public comment at your meetings. And at regular meetings, you'll have to allow time to comment on items not on the agenda and items that are on the agenda. At special meetings, you only have to allow public comment on those items on the agenda. So that's a distinction. And then, as I mentioned, you as the board have some options related to how you handle public comment. So one of them being that setting the time limit for public comment. The other is, and you could choose to hear all public comment for the entire meeting at the beginning of the meeting, or you could do what both boards currently do and hear items not on the agenda at the beginning of the meeting, and then hear public comment for each item as it occurs throughout the meeting. So those are options. So again, the Brown Act's very clear that you do have to provide time for public comment. The board really should aim to have fair and equitable treatment of all speakers. And this means enforcing the same time limits for everybody. This isn't the law, but it does allow or avoid complaints, by allowing everyone to have the same amount of time. So there are several reasons that constituents or the public come to speak at your meetings. This slide just kind of emphasizes those things. So they may want to make a public statement. They may want to go on the record as either supporting or opposing some issue. They may have a question. They may ask the board to take action on something, which we'll talk about on the next slide. Or they may just be raising a novel issue, something that you didn't even know was occurring in the city or hadn't heard before. So we have some recommendations related to responding to public comment. Items that are not on the agenda, the board can briefly respond to statements made by the public, or they can ask questions for clarification, but they can't discuss or take action on anything that comes up at public comment that's not on the agenda. And that just goes back to the tenet of the Board Act that you can't make decisions on something that's not on the agenda. You can request staff to report back on the issue at a subsequent meeting, or you could direct staff to bring the issue back to a future meeting. You just can't discuss it at that current meeting. When it comes to items that are on the agenda, the board can have a discussion based on public comment with one another, or they could have a discussion with the speaker. We typically recommend that you keep that relatively minor or minimal. But you do need to watch out because, and the reason that we make that recommendation is essentially that when you start to engage extensively with the people in the audience or with the public speaker, it does start to seem more like a public meeting as opposed to the board meeting in public that I talked about before. But again, when things come up at the lectern from the public, you can request staff come back to a future meeting with more information or anything like that. I'm going to talk about disruptions and how the Brown Act does and doesn't dictate how that occurs. So there really are no protocols within the Brown Act as to how to handle a disruption, but actions, it's important to keep in mind that actions that constitute disruptions are really highly fact specific, and that courts have analyzed them on a case-by-case basis. So for example, they've found that holding up signs at the back of the council chambers, that's distracting. The holding up signs at the back of the chambers would not constitute a disruption, but yelling or interrupting the speaker or any way disrupting what the business that the board's trying to take care of at their meeting would be considered a disruption.
And I am going to jump in here. So minor disruptions, counsel, you've been advised on those. And I'm not going to in any way waive the attorney-client privilege, but just keep that in mind that prior advice still stands. And so as Jennifer stated, there is very specific case law on this topic, and you've been advised accordingly. Thank you.
And so it is also important to differentiate between a disruption and criticism. So, the law says that the board can't prohibit the public from criticizing the board, the city, its procedures, its policies, or even its staff. The public has a First Amendment right to say mean things if they so desire. They just can't say them in a way that's disruptive or violent. So, the board does have the option, and I'm wondering if I should even go into this if Mary has already provided a memo of advice, but I'm sure this is something to this effect is in there. But basically the point of the meeting is for you to conduct your business. So if there is some disruption that's prohibiting you or for keeping you from doing that, then you do have the option of clearing the room and continuing the meeting. Or even better, it's a good idea to take a break. So you could take a 15-minute break and then have a recess, and then hopefully that gives the opportunity for the public to calm down and then resume your meeting. And then the last slide I have related to the Brown Act is just what are the consequences of violating the Brown Act. Intentional violations of the Brown Act are a misdemeanor. The district attorney or really any interested person could bring an action to set aside any decision that was made in violation of the Brown Act. They do have to first demand that you cure and correct. So they would demand that you fix the erroneous decision. But if that's not done, then the DA or some other interested person could bring an action against the city. And in that case, the prevailing plaintiff is entitled to attorney's fees and sometimes other costs. So basically the takeaway from that is that if you do think something runs afoul of the Brown Act, bring it up, because if you're currently in a meeting where something may have occurred, it isn't too late to correct it oftentimes. So that's all I had related to the Brown Act. Is there anything that you wanted to add, Mary?
Back up to that last slide. A violation of the Brown Act can be a crime. So we talked about the, ending up in court or paying legal fees for the other party, but also keep in mind that we want to avoid the grand jury coming in as well, because that is another consequence. That's it. Thank you, Jennifer.
Okay. Next up, I'm just going to talk briefly on Rosenberg's Rules of Order and then some other council rules that the city council has adopted for themselves. So the city has adopted Rosenberg's Rules of Order and certain other municipal code rules to as a way to govern the board meetings. And this is for both the Planning Commission and the city council. And in contrast to the Brown Act, these aren't law, they're not state law, but they're rather just procedural rules that are adopted to support orderly meetings. And you should have a copy of the Rosenberg's rules in your binder. So it's actually a pretty short and easy to read document. So I suggest you take a look at that. Oops. This slide just shows the general process for adopting a motion or discussing an agenda item according to Rosenberg's rules. So I'm going to go over it briefly because both of your boards do typically follow this process. So each agenda item is kind of handled by the board or by the board president. So that person facilitates the agenda item. So the mayor or the chairperson will announce the agenda item and then they'll state what the subject of that agenda item. Staff or other persons will provide a report on that item. So typically staff, but it could be someone else depending on what the item's about. The board members are then invited to ask staff or whoever provided the presentation clarifying questions. The mayor or chair will then invite public comment, and that's all subject to those Brown Act provisions that we just discussed. The mayor or chairperson will invite a motion. They will then invite a second. And this is something that I haven't seen done, but is a best practice. The mayor or the chairperson can then make sure everybody understands the motion. And to do that, they can either ask the maker of the motion to repeat it. They themselves repeat it just to make sure that it's clear to everybody. Or they could even ask the secretary or clerk at that current meeting to repeat that. And then the mayor or chairperson will open up the agenda item to discussion and debate amongst themselves. When they're ready to vote, they'll repeat the motion if necessary, take a vote, and then announce the results. So the mayor or the chairperson does have some special roles under Rosenberg's rules. And as I mentioned, they're in charge of conducting the meeting and conducting each agenda item. But they also make final rulings on procedure unless their ruling is overruled by the rest of the board. It's also typical for the chair or the mayor to play a less active role in the discussion or debate. So they themselves won't typically make the motion or the second, and they'll often wait to do their own comments or discussion till last. And then in addition to Rosenberg's rules, there are some rules that the city council has adopted that are in the municipal code, and these are in chapter 2.04. I'm just going to go over two of them. This is not comprehensive. There are more. But 204.020, elected and appointed officials' conduct with each other in public meetings. So the council has established some protocols for themselves when it comes to conduct with one another. They're going to practice civility and decorum in discussions and debate, avoid personal comments that could offend other members, demonstrate effective problem-solving approaches. And then there's also a rule adopted that relates to your conduct with the public. And so those protocols are: be welcoming to speakers and treat them with care and gentleness, be fair and equitable in allocating public hearing time to individual speakers, practice active listening, maintain an open mind, and ask for clarification, but avoid debate and argument with the public. Do you have anything to add, Mary, to that Rosenberg's rules or council rule discussion?
No, I don't. Thank you.
All right, moving on to the CPRA. I started to jump ahead earlier. But the California Public Records Act, it was passed by the state legislature, signed by the governor in 1968. And it basically requires inspection or disclosure of governmental records to the public upon request, unless those records are exempted by law. And the CPRA is governed by three guiding principles, and those are transparency, access, and disclosure. So the idea is that transparency is is providing transparency to the business, to the public of the people's business. So basically the business that you take care of is the public's business. And so by providing them the records that are generated in city business, that's providing transparency. The CPRA also provides access to the public so that they can monitor government activity. And then in general, the CPRA is really favors disclosure. So on the next slide, I'm going to talk about exemptions to the CPRA, but really the general rule is that all public records are disclosable. This slide gives some examples of what is a record, but it is not a comprehensive list. So the law says that a record is any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. So as I mentioned, this slide shows some examples of records, but in addition, photographs and video are records, emails are records, communications, other communications with the public are records, financial records are records. So keeping that in mind, not everything is a record. So a record is only something that is kept that is related to city business. So there are things that may turn up in your email, for instance, that aren't actually records. So as I mentioned, there are exemptions. So there's quite a few exemptions. Some examples are drafts and notes not retained in the ordinary course of business. Certain personnel files are exempt. Attorney-client privilege documents are exempt, and then documents related to pending litigation are exempt. And our office frequently works with city staff to determine whether or not documents are disclosable or not. And then another point is that records they can lose their exempt status. So a record may be exempt, but if it is then distributed in some way to the public, then it's no longer going to be exempt from the CPRA. There is a catch-all exemption, and this is, it requires a balancing test. Basically, it asks, is the public interest served by not disclosing the record clearly outweighed by the public interests served in disclosing the record? It's a pretty burdensome argument because the court favors disclosure. It's typically difficult to rely upon this exemption, but it is available if necessary. And then this is what I started talking about earlier, but because I was out of order. But basically, when it comes to your emails and text messages that you send using your city devices, it's relatively obvious that those are subject to the CPRA. But in addition, there was a court case in 2017 that found that in addition, if you use your personal devices or your personal email address to conduct city business, those are also subject to the CPRA. So it's just something to be mindful of. So any email or text message that you send from your personal device, if it's related to city business, could be disclosable to a member of the public. And then that's all I have for the CPRA, Mary. Is there anything you wanted to add to that?
Just this idea that, hold on just a moment, just this idea of your personal items. So if we get record requests, and this goes for anybody in the city, this goes for the commissioners, this goes for staff, council members, if we get a records request and we think you might have something on your personal device, your personal laptop, we're going to have to give you an affidavit and have you search your records, because by law, we can't take your devices without a warrant. So we'll have you certify under penalty of perjury that you checked your records and that you were able to find certain records and you provided those, or you weren't able to find any responsive records. And then we have that document for if we're ever challenged, because it's our job to protect the city. And that's how we can best protect it when we get these requests where it requires you to look at your personal device. Thank you, Jennifer.
So I'm going to stop for questions because I've covered that board governance section of the presentation, and we'll be moving on to items that are more specific to planning and development. So just wanted to pause and ask if there are any questions related to what we've covered so far.
All right, is there any questions? Anyone?
All right, so we're gonna do what I call land use 101, but essentially what it is just a really high level presentation of land use and development law. And this body of law is very large, it's complicated, it's nuanced. And so this, like I said, is meant to give you a very high level understanding of some of the issues that come up at your meetings. It's in no way comprehensive. So these are the items that we're going to cover. I won't read them, but it's quite a bit of information, but again, I'm going to keep it at a very high level. So starting with the general plan, what is it? The general plan is essentially the foundation for all local land use planning. And so the city adopted its current general plan in 2005. And with that plan, it created a vision for Hollister, and it translated that vision into objectives and goals and policies and different programs for the physical development of the community. And so, as you know, the city is currently updating that general plan. So that'll come to you soon. The general plan covers all of the land within the city, but in addition to that, it covers any land that the city's judgment bears any relationship to its planning. And so you'll hear that referred to sometimes as the sphere of influence. All other land use ordinances, policies, everything else flows from the general plan. So that means that zoning ordinances and then even individual projects are required to be consistent with the general plan. The general plan has 7 required or mandatory elements. Those are up there on the slide. I will give you a very brief description of each of them. The land use element designates and provides a diagram or map illustrating the general type, intensity or distribution of various land uses. Circulation element describes and provides a circulation diagram or map that illustrates it illustrates the existing and then also proposed transportation routes and other local public utilities and facilities. The housing element identifies and analyzes the existing and also projected housing needs for all different economic segments of the community. And this is consistent with the regional fair share allocation of housing needs established through regional housing process, which you've probably heard referred to as RHNA. The conservation element provides for the conservation, development, and use of natural resources. The open space element details how open space, recreational areas, and also natural resources will be preserved and managed. The noise element establishes noise contours and standards, and it identifies and apprises noise sources and problems, and then includes implementation measures to address those problems. And then the safety element addresses protection from unreasonable risk of things like fires, earthquakes, floods, those sorts of things. And some of the elements get more scrutiny than others. So the housing element, for instance, has numerous requirements for its adoption and amendment, and it has to be reviewed and approved by the State Department of Housing and Community Development, which you've heard called HCD. And then there are optional elements. The city currently has one optional element, which is the community services and facilities element, and then they plan to add additional optional elements with the general plan update. So I did mention that all land use and policies flow from the general plan and that they have to be consistent with the general plan. We refer to that in 2 ways. We talk about horizontal consistency and then vertical consistency. So horizontal consistency just means that the individual elements within the general plan must be integrated and they must be consistent with one another. So there has to be consistency among the different 7 mandatory or any optional elements. There has to be consistency within each individual element. And then there has to be consistency between the language of the general plan and then the maps that are included. So everything just needs to be consistent with one another. And that's horizontal consistency within the general plan. Vertical consistency, on the other hand, just means that all plans, ordinances, policies, anything related to land use is consistent with the general plan. So all has to be consistent with one another. So for example, subdivision and development approvals have to be consistent with the general plan. So I think that covers that. So although the general plan is a long-term plan that's meant to create a vision into the long term for the city, you can amend or update it. And also the adoption of a general plan doesn't guarantee on its own that there's going to be orderly development in the city. So the city council and the planning commission actually play a really critical role in ensuring that the vision in that plan is materialized. So state law also requires that there's annual reporting on general plan implementation. And so those reports really let the city see that their recent land use decisions are consistent with the goals of the general plan. And it allows them to assess that the plan is being implemented and then identify any modifications or improvements that need to be made to the general plan. So as I kind of alluded to, the general plan is a living document, meaning that it can change as conditions in the community change. However, because it is meant to be a long-term plan, those mandatory elements of the general plan, those 7 elements, can only be updated 4 times per year. And the optional elements can be updated as many times per year as the city chooses. Project proponents can also, you've probably seen this, but project proponents can also propose general plan amendments, not just the city. And then amendments are adopted by resolution after a public hearing. And so then similar to amendments, you can also have a general plan update, which is currently occurring. And these updates just again ensure that the long-term vision for the city is presented and reflected in the plan, or continues to be reflected in the plan. The other point that I will make is that updates aren't required to be on a fixed schedule. The only exception to that is the housing element, which does have to be updated every 8 years. And now I just have one quick slide on, not very far, on specific plans. So specific plans are optional, and they're just used as a flexible planning tool that addresses specific areas in the city. They're often a bridge between the general plan and zoning regulations that are just used to more accurately define a specific area in the city. And Hollister does have one specific plan for the, and it's for the west of Fairview area. Right, we're going to move on to zoning regulations. So historically, zoning is the separation of the community into different districts or zones that regulate land use and intensity of development. So a zoning designation is assigned to every single parcel in the city. And the goal really is to assure that neighborhood land uses are compatible. So you're not going to end up with some industrial manufacturing facility next door to a single family residence. So before approving or denying a project, the city must determine whether that project complies with the provisions of the local zoning ordinances. And that's one of the things that staff does as they prepare to bring an item before you. Zoning regulations, again, have to be consistent with the general plan. And zoning regulations are deemed valid if they are reasonably related to the community welfare and don't conflict with state law. So this is important, and I will talk about later in the presentation, I'll talk about the police power and where the city gets its authority to establish zoning regulations, but this is just kind of alluding to that later conversation. The city zoning ordinances list land uses that are allowed by right for each zone, but by right doesn't guarantee that there's an unconditional right for a particular use on a particular property. It just means that the permit is not subject to a discretionary review. The Planning Commission is responsible for making zoning decisions of discretionary applications under the zoning ordinance. And if you're interested, the city zoning code is Title 17 of the municipal code. There are some exceptions to zoning regulations. Variances and conditional use permits are administrative discretionary approvals that will allow for a deviation from zoning regulations where a property is uniquely situated or where the use can be acceptable if certain conditions are first met, which I'll talk a little bit more about that in a second. But before I do, I want to touch on non-conforming uses. So there are, a non-conforming use is essentially when a use on a property does not comply with its own zoning designation. And there are two types of non-conforming uses. There's the legal non-conforming use, which occurs when the property was, or the use was in place prior to the adoption of the ordinance. And in those cases, the use is typically allowed to stay. It's just not allowed to expand or be replaced. And so that's what we call a legal non-conforming use. An illegal non-conforming use, on the other hand, is something that was built after a zoning ordinance was in place. And those uses are not permitted. So the city does have the right to require that those uses are terminated, regardless of the property owner's investment. So those are typically addressed though through code enforcement. So conditional use permits are something the Planning Commission sees quite a bit. And those are land uses that are approved under the zoning code, but only if they meet certain, oh, I might forget, sorry. It's just like hit me or something. All right, keep this in my hand. So conditional use permits are land uses that are approved, but only if certain conditions are met. So a conditional use permit does allow the city to more closely review individual projects that could negatively affect the neighborhood land uses. And staff and the Planning Commission can develop a set of conditions that would minimize that negative impact before they authorize that the development occur. Conditional use permits are granted on the land and not the property owner. So if the property sells or changes hands, it will remain with the property. And conditional use permits can be revoked. So if they are non-compliant with those conditions, it can be revoked, but that revocation is first subject to a notice and a hearing. And then lastly, conditional use permits are, they're required to be supported by findings. And I'm going to talk a little bit later about what findings are as they relate to decision-making, but just keep in mind that conditional use permits are one of those decisions that would require findings. And variances, on the other hand, they're different. So they are also a limited waiver of the zoning standards, but they are only permitted when that use is actually permitted in the zone. So a variance can't be used to permit a land use that wasn't already authorized in a specific zone. And they're only considered under really extraordinary circumstances that relate to the property itself. So if there's something about the property's size or its shape, topography, location, surroundings, something about the actual physical land that would pose a unique hardship to the property owner, then a variance could be granted in those special cases. And that's typically, the analysis is typically whether or not they are being deprived of some use that someone else in their zone or their neighbor would be allowed to do because of something related to the actual physical land that they own. And economic hardship is not a sufficient justification to approve a variance. It has to be something else, something related to the land itself. And again, variances are also required to be supported by findings. We'll talk about in a bit. So real quick comment on design and architectural review, which is another item that the Planning Commission sees quite a bit. Design and architectural review is used to ensure that new development is compatible with the aesthetic character of the city or the community that it's in. And the city may require discretionary design and architectural review just so long as it's reasonably related to the public health, safety, and welfare, and if it doesn't conflict with state law. Subdivisions, I'm going to talk about the Subdivision Map Act, which governs the process for dividing land into separate parcels, which we call subdivisions. Subdivisions do require the adoption of a local ordinance, which can include provisions in addition to, but not conflict with the Subdivision Map Act. So again, it's an ordinance that can be adopted as long as it doesn't conflict with state law. Through the MAP Act and those local ordinances, the city can impose significant conditions on subdivisions and parcel maps. And I'll talk about the distinction between the two in a second. So on this side, though, you do see the general process for a subdivision, and it starts with a tentative map. And that tentative map depicts the design and improvement of the proposed subdivision and the existing conditions that surround it. So when the city receives that tentative map, it reviews the map to see if it meets local subdivision and zoning requirements. And then the city may impose conditions of approval to ensure that the development of the project is consistent with the general plan, zoning, engineering and building standards, and environmental mitigation as well. And once that tentative map is approved, the applicant then prepares a final map, which is typically much more technically correct, and incorporates those conditions that were imposed by the city at the tentative map stage. And the final map approval of the final map is a ministerial act. So there is no discretion to reject the final map if all of the conditions that were set with the tentative map have been approved. So it's important to keep in mind. And then at the last step, that approved final map is recorded with the county, and the applicant can then proceed with their development. So there are, as I mentioned, two different kinds of subdivisions. There's a major subdivision and a minor subdivision. The key distinction is really the size or the number of parcels. So a major subdivision is 5 or more parcels. They do sometimes require a more formal procedure. So the Subdivision Map Act itself, the state law, does require the formal procedure that I just talked about for major subdivisions. But then it does leave to local jurisdictions how they want what they want to require for minor subdivisions, which are 4 parcels or less. The city of Hollister does require both a tentative and final subdivision map for parcel maps or minor subdivisions. But that's not required by the state law. And then another primary difference between the two major and minor subdivisions, other than the size, is the number of conditions that can be applied. So with a minor subdivision or a parcel map, the city can only impose requirements for the dedication of rights of way, easements, and the construction of reasonable offsite and onsite improvements that are related just to those individual parcels. So that would be for a minor subdivision, where with, I'm sorry, a major subdivision, no, minor subdivision. And then where for a major subdivision, more conditions could be required. The Permit Streamlining Act is something that really generally comes into play at the staff level. So I'm just going to briefly touch on this, but essentially it's a time clock on the review and processing of discretionary land use permits. So applications are deemed approved if certain timelines aren't met. So staff is required to meet strict timelines for those projects that are subject to the Permit Streamlining Act. And legislative acts and CEQA actions, I'm going to talk a little bit about legislative acts later, and CEQA action are not subject to the Permit Streamlining Act. Housing is, as you know, an important issue currently. So the lack of housing in California has been deemed a critical problem, and the legislature has determined that the problem warrants multiple interventions. So that includes prohibitions on barriers to housing, incentives for affordable housing, and ensuring that there's infrastructure support for housing. And there's a whole myriad of laws that have been passed in relatively recent years, and these are just some of them. And I'm going to just briefly discuss because I think that we could probably talk about housing laws all day long. So the density bonus law is something that requires that mandatory concessions be granted to a developer if they're proposing to build affordable housing. The housing accountability law places certain limitations on the ability of local agencies to restrict housing. The accessory dwelling units law, it requires ministerial approval of certain accessory dwelling units and junior accessory dwelling units. And then there are laws that prohibit growth management policies or ordinances that limit the number of housing units. And these policies or ordinances they're subject to scrutiny and require that certain findings are made to show that growth management policy is in place to protect health, safety, and welfare. So basically, the bottom line is that the state's really interested in additional housing being met, and they're passing laws that are requiring cities to facilitate that goal. So CEQA is a pretty complex law, but it has a pretty simple purpose. So basically, it's in place to assure that decision makers such as yourselves understand and account for the environmental consequences of a project. And the purpose of CEQA really is informational. So it gives you decision makers information on what environmental impacts of a project will be and how those impacts can be minimized. So CEQA doesn't apply to everything, but it does apply to everything that is determined to be a project by CEQA definition. So the city can approve, or they may not approve projects if there are alternatives or mitigation measures that could substantially lessen the significant environmental impacts of the project. So CEQA applies to all discretionary decisions regarding projects involving government action. So things like land use approvals and public works projects, but it doesn't apply, as I mentioned, to everything. So it doesn't apply to ministerial actions like building permits. It doesn't apply to decisions that are going to have no adverse impact. It doesn't apply to project denials. And it also doesn't apply to preliminary actions that don't actually commit to a project. So the bottom line is CEQA requires decision makers to just consider the environmental consequences of an action before that action is actually taken. And there are numerous exemptions, both statutory and categorical. And the difference is that the statutory exemptions are granted by the legislature and they're absolute. One example is from emergency projects. And then categorical exemptions are established by the Resources Agency. And those, an example of one of those would be just the replacement or reconstruction of an existing facility. But there are many more exemptions. Kind of the broad overview of the CEQA process is on this slide. And we did already talk a little bit about what is a project, or it's required that it be a project under CEQA definition, whether or not there's an exemption. And then if a project is not exempt, then the city must complete an initial study to determine if there are adverse changes to the environment that will result from the project and whether those adverse impacts can be mitigated. And so after that initial study, the city will determine what type of report needs to be prepared. And so that can either be a negative declaration, a mitigated negative declaration, or an EIR. A negative declaration or mitigated negative declaration is prepared when that initial study shows that there are no significant impacts likely to result from the project, or it concludes that those impacts can be reduced by requiring proper mitigation. An environmental impact report is required if those significant impacts are identified and they're not reducible through apparent mitigation measures. I'm going to talk briefly about vesting and development agreements. So in general, cities can change land use policies and property owners are required to follow those new policies. So if a zoning regulation changes, you're subject to the new regulation, or a property owner is. And this is only not true if there are vested rights, meaning the property owner is vested in some past decision. And those only occur when the developer or the property owner has vested substantial monetary costs in a good faith reliance on a validly issued permit. So if there is no validly issued permit, or they haven't expended significant costs, they haven't been vested in those previous rights. We call that the AVCO rule, just because that's the case that established that rule. There are quite a few exceptions and nuances to that rule. So I would say always consult with us if something like that comes up that you have a question about. But that's the overall general rule when it comes to vesting. The development agreements are a way that developers can become vested by agreement. And so a development agreement is a contract, and it's a contract between a city and a developer that establishes a set of standards or fees, and often certain city benefits that will then lock in those rights or those standards and fees that are included in the agreement for the developer. So typically it's a way for them to get to vest. Development agreements are subject to CEQA, and they must be adopted by ordinance, and they are subject to referendum. This is my last slide on Land Use 101. So we're going to talk about dedications and fees. So dedications of land and development fees are imposed on projects because development impacts infrastructure is really the short story. So dedications and fees are imposed as conditions of projects to offset the new demand that's placed on public services and facilities because of that development. You'll sometimes hear dedications and fees referred to as exactions. So a dedication, to distinguish between the two, dedications when physical land is actually transferred from the property owner to the city. And then fees are often paid in lieu of a dedication because it doesn't always make sense to grant land when it would be either easier to pay or perhaps the infrastructure being impacted, the sewer line and the land that the property owner possesses isn't going to be suitable for a sewer line. Let's see here. So the important thing to remember when it comes to dedications and fees is that they must be related to the purpose and they must be roughly proportional to the impacts. So what that means is a small development that's only going to have a minor impact on traffic, for instance, wouldn't be expected to pay for an entire freeway interchange. So what a particular developer is expected to pay needs to be reasonably related to the impact of their particular development. Mary, that's the end of my Land Use 101. Is there anything you wanted to add to any of that?
No, I think you covered it. Thank you, Jennifer.
All right, so we're going to move on to roles and responsibilities, and this was the actual title of the agenda item. So let's talk about this. So a lot goes into good planning and land use and development policies and procedures. And so this slide, this slide shows all of the parties involved. So the big picture is really that that good planning and development policies and procedures are necessary to meet the present and future needs of the city of Hollister. And planning involves a broad spectrum of activities, whether it's brand new development or reconstruction of an entire neighborhood or what be it. So there's a lot involved and a lot of parties. So this slide shows you all of the different parties. We have the city council, the planning commission, city staff, the public, and the city attorney. I'm going to start with city staff. So city staff here at this table, they act as your technical staff to both the planning commission and the city council. So they're the ones who are preparing the ordinances and plans that come to you for approval. They're identifying local regulations that apply to the applications that they're receiving in their office. They organize these hearings and meetings. They work with applicants to ensure that their projects comply with community policies and then also local and state law. They coordinate with other departments. So your planning staff coordinates with the engineering department or even the county or whoever necessary to incorporate their technical comments into the projects that come before you. They ensure that appropriate procedures are followed. So whether it's notification in advance of a hearing, those sorts of things. They prepare their professional analysis and recommendation to the planning commission and the city council. And then once projects are approved, they monitor that project's implementation and whether or not it continues to remain compliant with policies or the conditions of approval. Before I talk about the planning commission and the city council specifically, I do want to talk about three different categories or three roles that the two boards play. So at different times, local officials will play different roles. And so those are up here on this slide. There's the legislative role, the quasi adjudicatory role, and then an enforcement role. So legislative role is when you are adopting broad policies. So when you're adopting ordinances, general plan, those broad policies that are going to dictate, activities into the future. Quasi adjudicatory is when you're applying those policies to a particular project. So that's when you're playing a quasi adjudicatory role. And then at times you will play an enforcement role, which is really just ensuring that projects are complying with applicable laws and those conditions of approval. So more specifically, the Planning Commission serves as an advisory body to the City Council on all planning and development issues. Oh, thanks. They review development applications and then make factual findings on a case-by-case basis to ensure that projects are consistent with the general plan, local plans, policies, and ordinances. The Planning Commission public hearings are a really important venue for the community to come out and hear about planning issues, learn about planning issues, and express their opinion about planning issues. It functions as the primary decision-making body for a lot of planning applications. Those are sometimes subject to appeal to the City Council, but in a lot of cases, they're the primary decision maker. The Planning Commission can act as an appellate body to staff decisions. So those types of planning decisions that are made at the staff level, often if an applicant wants to appeal that decision, they go to the Planning Commission. It's important that the Planning Commission is mindful of due process and property rights when they make the considerations that they have before them, and we'll talk a little bit about those in a little bit. It's also important that individual commissioners are aware of that their communications can impair their role as an independent and unbiased decision maker. So Mary alluded to this a little bit earlier, is if you're communicating with other commissioners or making public comments about maybe how you're going to decide a project prior to the public hearing, you're supposed to reserve your decision making until you've heard the evidence at the public hearing. So you could compromise your unbiased role if you're making comments, be it in public or social media or what have you, prior to a public hearing. Assuming that you planning commissioners are acting in your official role, you will be indemnified from liability that arises out of the performance of that duty. So if you're acting as a planning commissioner, you're indemnified from liability in that role. The Planning Commission has no formal appointing authority or oversight over city staff. You can certainly make requests, ask for information, anything that's going to support those recommendations that they bring before you, but the staff doesn't report to the Planning Commission. And then lastly, the Planning Commission makes recommendations and policy suggestions to the City Council. The City Council has, some of its roles are very similar to when it comes to planning and development to those of the Planning Commission. So again, they're going to evaluate the analysis that comes to them from staff, the recommendations that come to them from the advisory bodies. And then they are responsible for a lot of the final decisions related to land use plans and proposals. So if you think about the general plan or ordinances, those are ultimately decided by the City Council after recommendation from the Planning Commission. City Council serves as the appellate body to Planning Commission decisions. So if a applicant is dissatisfied with the decision that the Planning Commission made, that can be appealed to the City Council. Again, similar to the Planning Commission, City Council meetings are an important venue for the community, anyone interested in planning and development matters or any matter for that matter, that they want to learn or hear more about what's going on in the city. Your City Council meetings are an important venue for that. Again, the City Council, just like the Planning Commission, should be mindful of how their communications might impair their role as independent and unbiased decision makers. So just being mindful of the comments or conversations that they have related to future decisions that they'll be making. Just like the Planning Commission, the City Council will be indemnified from liability arising out of the duties of their official duties. And then again, the city council, like the planning commission, doesn't have direct oversight over staff. But they do have the ability and are expected to ask for clarification or additional information or anything that's going to help them make their decisions from staff. The city attorney advises you, the officials, on legal process requirements for decision-making. So things like public notice obligations. They answer questions about applicable law and how that law applies to particular situations. We distinguish between legal advice and policy advice. The city attorney provides legal advice, which typically comes in the form of recommendations or a risk analysis, but then the city is responsible for making policy decisions. And then the city attorney represents the city in legal issues and disputes. And last up, the public. This is just a fundamental part of our democracy. Engaging the public in planning and land use decisions helps build a sense of connection to those decisions. It also, more knowledgeable residents are typically going to be more understanding of the difficult decisions that you have to make, or, the more they know, the more they understand the different pieces at play. And then public engagement really, it enhances community buy-in and support of those policies that are ultimately decided. So if they have an opportunity to comment and assist in making those decisions, and they typically have a higher level of buy-in. Do you have anything to add to the section on roles and responsibilities, Mary?
No, I don't. Thank you.
All right, we're in the home stretch. Our last section here, this is just particular legal issues, and this is not an extensive list like any of the presentation, but these are some typical legal issues related to land use planning development that it's important to be aware of. Because as you know, land use is contentious, and developers want their entitlements. Environmentalists want to manage growth. Neighborhood organizations want to be involved, and then there's any number of other groups that have an interest in those decisions that you make. And sometimes this creates a catch-22, because the developer will sue if their application is not approved, and then some other opposition group will sue if their application is approved. So it really puts you in a difficult position. So in that respect, our recommendation is that by properly managing the review of projects and properly following policies and procedures is one of the best ways to mitigate that risk. So again, this means having well-defined plans, like a well-defined general plan, ordinances, policies, and those policies will help you all make informed decisions. So the second point here, due process, is it's important to be aware that those affected parties, so those parties who are affected by the decisions that you make, they have a right to a notice, so to be notified in advance and to a hearing. And so that's a lot about what the purpose of your public hearings essentially is, that those affected parties will have notice in advance and then an opportunity to appear or be heard at a public hearing when some decision is going to impact them. And there's a number of laws that impact this. We talked about the Brown Act, and then there's other planning and zoning laws that require certain notifications in advance of certain actions. And then the third point here, findings, I've alluded to a few times, and I will talk about more, I promise. First, I want to talk about the police power, and this is really where cities and local agencies get their authority to make these types of laws or regulations. So local ordinances, I'm just going to read the quote on the slide. It says, a county or city may make and enforce within its limits all local police, sanitary, and other ordinances and regulations not in conflict with general laws. And this comes from the California Constitution. So local agencies derive their authority to shape communities through planning and development through this provision in the Constitution, which we call the police power. This also is present in the United States Constitution. And it's pretty broad. So cities and counties typically have a very broad authority to take action that's intended to protect general health, safety, and welfare. And general health, safety, and welfare is also pretty broadly defined. And so, the primary thing to keep in mind is you do have this broad authority, but then there are times when it may conflict with state law, and that's when that authority is essentially taken away. And so the Constitution has been around for a while. And so that local authority, though, has changed over time. So as the need for different types of land use authority has changed over time, so has your ability to pass those kinds of regulations. So I think about affordable housing 100 years ago, that may not have been an important issue, and it is today. And so that's how that purview of the police power has changed. So 100 years ago, a city council would not have probably considered passing a law related to affordable housing. And today it's something that's talked about often. And so, as I mentioned, the definition of health, safety, and welfare is very broad. So courts have found that could include things like socioeconomic balance. It can include aesthetic values, so those design standards that we talked about, property values, residential character, growth management. So all of those things have been determined at some point in the recent past to be a part of health, safety, and welfare. A preemption is the idea that local regulations can't conflict with overriding state law. And we are seeing that now with some of the new housing laws. The state is passing laws that the cities are required to adhere to, and they are currently in conflict with local regulations. And so we have to kind of disregard those local regulations and update them. But in the meantime, comply with the state law without regard to the local law. The takings clause is, again, another constitutional concept, and basically it says that private property can't be taken or damaged for public use, or it only can be taken or damaged for public use when just compensation is paid to the owner. And this is the taking, this is often misunderstood. So it doesn't mean that any decrease in property value or anything that prohibits an owner from doing anything that they want with their land is not a taking. So you might hear that proposed. Someone may propose that the city is taking their property if they're forbidding them from doing what they want with their property. But the courts have really recognized that cities and local agencies do have the right or the ability to regulate land. And they've also recognized that, your ordinances may just as easily increase people's property value as decrease them. So there's certain actions that the government or that the courts have said are takings. And you'll hear, I think, that these are relatively extreme. So if the city takes action that has and impacts someone's land value, and that action has no legitimate public purpose, that would be considered a taking. If they deny a property owner of all viable economic use of their property, so not necessarily the use that they want, but all economic use is, if that's taken, that would be a takings. And then if there's no nexus between the impact, this is going back to that rough proportionality idea that the taking by the government or the city has to be proportional to the public need. And if it's not, then that would be considered a taking. My last slide. All right, so I am going to finally talk about findings. Findings are essentially, they articulate the reason for your decisions, and then they create a record. And those findings must include evidence to support the findings, so they can't be conclusory. They have to have supporting facts. And those facts don't have to necessarily be written into a resolution. They can come in the form of staff reports, PowerPoints, testimony, environmental impact reports, exhibits, like all the different items that come into the public hearing could be considered findings. And they are often statutorily required. So certain decisions, like I talked about earlier, variances, conditional use permits are all, you're going to require to make findings before you can make a decision. But they're not, so they're always required with those quasi adjudicatory decisions that I talked about, where you're applying the regulations to a specific instance. They're not required with legislative action. So when you are adopting an ordinance, or something to that effect, but they're often helpful and also advised, particularly if it's a controversial issue. It's a good idea to document or have findings as to why that decision is being made. You have anything to add, Mary?
No, thank you, Jennifer.
Are there any questions?
Any questions from anyone? No.
Come on.
You're so good. You
Oh,
covered it
yeah,
all.
sure. All right, well, that's all I had.
Well, thank you very much for all that.
I know it was long, but it was a lot to cover.
I was teasing her. She exceeded our 5-minute
About
allotment.
5 minutes. Okay, well, thank you. Why don't, go ahead, sir.
Thank you, Mayor. I would like to make a recommendation moving forward, though. This is very helpful. It reinforces some things I knew and corrected some things I was wrong about. Having said that, I know we're in an election cycle, and at some point, we may have some new elected officials or the same officials. And so I would like to recommend to the city that this be a training that's done every year, preferably in January, as new councils or re-elected councils relaunch. I think it'd be very helpful as opposed to, I've been on council now about 18 months. And so this would have been very helpful. And thank you for your presentation. Thank you, Mayor.
Perfect. Why don't we take a 10-minute break before we get started on the next item? All right, let's move now to item B2.
Great, thank you. Good evening. This is a loud microphone. Good evening. This item is hopefully going to be briefer than the first, but thank you so much, Jennifer, for that presentation. We've been hoping to have everyone here together for a joint session. We've been hearing as planning staff for a while from our commission to have kind of a roles and responsibilities discussion. This second item that the planning department wanted to bring forward to the joint board tonight is just a discussion of the possibility of having future study sessions. We'd like to essentially do quite a few zoning amendments, some having to do with state law, some having to do with just clarifying things that that'll make it easier for staff and the board and the community to clarify items that aren't clear in the zoning ordinance. And ultimately, it's going to come down to pretty much an overhaul of the entire zoning ordinance. So staff would like to host more of these study sessions to have an opportunity to discuss different sections of the zoning code and kind of hash out ordinances, hash out points of contention, and make sure that everything's clear with both of our members of the boards at the same time. And then we would formally bring forward ordinances on kind of a rolling basis. And I didn't do this, but I am Eva Kelly. I'm the interim planning manager. And then this is our senior planning staff team. So this is Adriana Ortiz, our community development director. And then we have Erica Fraser to my right, senior planner, and then Amber Cameron, also senior planner at the end of the table there. So Erica, I'm going to pass this over to you because she has been leading the way on kind of getting this zoning amendment started.
So Eva kind of covered it, but as part of this discussion, we're going to discuss what staff would like to do as far as overhauling the zoning ordinance and the phasing that we have kind of established to carry this forward. So right now, staff recently met with the Planning Commission, and there are a few zoning ordinance amendments that are moving through the pipeline. At the last Planning Commission meeting, the Planning Commission adopted a resolution recommending that the city council on September 19th is when it's scheduled for amend minor amendments to the zoning ordinance related to density. That's moving forward right now because we need that to be cleared up so that staff can consistently moving forward, as well as the Planning Commission and City Council, consistently evaluate the density of residential projects. So those are very minor amendments that you'll see in a couple of weeks. That's not within this phase that we're talking about, or this overhaul that we're talking about. There are 3 phases that staff has identified for the zoning ordinance overhaul. Phase number 1 is also actually underway. During a study session on August 4th, staff brought the issue related to two sections of the zoning ordinance. We discussed what current state law was, how we needed to change our zoning ordinance to comply with state law, and we discussed those. And those modifications are related to Senate Bill 9, which is a Senate bill that was recently adopted that allows for lot splits and 2 units on a property. There's also been many changes in the density bonus law since we last updated that section of the zoning ordinance. And so that section is completely inconsistent with state law and has to be totally redone. And then, well, we have been updating accessory structures quite regularly. There have been more recent changes. That law seems to be updated on a quite regular basis. And so we need some changes to comply with state law. Staff is currently working on drafting those ordinances, and hopefully a near future date, we'll be able to bring it before a study session for you to look at what the text of those changes would look like, and also Senate Bill 9, which would be in its own section of the zoning ordinance, since that's obviously not in there now. Phase 2, once that phase is done, would include an overhaul of our site and architectural review section of the zoning ordinance. Things we've identified to change at this point, which may change later once we start reviewing it more. We'd like to clarify which projects require planning approval. We'd also like to include specific project findings that are required as for the planning commission and for staff to make when reviewing projects that require site and architectural review. We'd like to make the section more user-friendly so that it's easy for property owners or developers or applicants, whoever the case may be, so they can easily use the section, determine if they need a permit, and then how to move forward. So it's not as confusing as it is now. We'd also like to amend the section to provide more clarity. Again, that helps with making it more user-friendly. As part of this site and architectural review, staff is also working on preparing some design guidelines that would be for certain sections of the city. We'd like both of them to go together because we'd also like to include findings in this section related to the design guidelines, and also so people are aware when they're maybe just looking at this, that we also have some design guidelines that they need to look at. We'd like to take both of those things together for you if they're done at the same time, so that you could also review it together at a joint study session. Phase 3 would then be the largest portion of the overhaul. Again, we're trying to make the zoning ordinance more user-friendly. Things have changed with how planning works now. Things are changing in the community, and we'd like to make sure that the zoning ordinance is consistent with all those practices. Again, trying to make it more user-friendly so that it's easier for the public to use. They're using it as well as we are, and so we should ensure that it's easy for them to use, that they can understand it, that it's consistent within itself. We also are aware of modifications that the city council has been requesting be made to the zoning ordinance, and we'd like to wrap them up into this phase so we can hit it with each section. And as part of the 2040 Hollister General Plan update, we anticipate that there will also be some changes that will need to be made for consistency with the general plan. What we'd like to do again is to review these changes during a joint study session because we anticipate that they will be extensive. We'd like to hold a study session once per month. And what staff would do is bring draft sections, one or more, depending on how many changes we're making, to each study session. It could even be that there could be so many changes that we can't bring an entire section, but at least we'd use that time wisely to discuss the section, changes that we've been able to make, and how to move forward with the rest of it if we have questions. Once the draft is before you, obviously at the meeting, if you ask us for more changes or you have more questions, we would either come back to you with some answers or some revisions for you to look at, or if they're minor, we'd incorporate it, and that would be incorporated into the final draft. Once all the sections have been reviewed, we would then bring it to the planning commission during a public hearing. The planning commission would make a recommendation to the city council, and then the final step would be, we would then go to the city council. We would have the city council repeal the entire existing zoning ordinance and replace it with the new one that we've all worked together. So in conclusion, we have some minor modifications related to the zoning ordinance currently underway. Phase 1 is also currently underway, but that's moving at a slower pace because it's such an extensive modification that we need to make. And staff is requesting that the city council and planning commission hold a joint study session once a month to facilitate this overhaul of the zoning ordinance. That concludes my presentation. I'd be happy to answer any questions that you have.
Go ahead, Mr. Burns.
Thank you, Mayor. Thanks for the presentation. I sense it's well overdue. Having said that, I do have just a couple of questions for you. First of all, do you have adequate staff, resources, and capacity to do this, or would this be better outsourced to a consulting firm to do?
Currently, I work for Four Leaf, and so does Erica. That is one of the best part about having that, is because we can tap into our resources, which we do. Actually, Erica takes on projects, some of the ones that have been extended or have been challenges, and so she's been quite the help for staff. We are still understaffed, so I'm working on filling more of our positions, but we have actually filled planning tech, associate planner. We have now 3 senior planners and myself, which has been extremely helpful to start moving things along, which is why we're able to bring this to you. We have talked about doing the workshop that we initially did since the attorneys came on and just haven't been able to come around to it until now. And in addition to all of the ordinances that I know that you guys have requested over time, and they're very important to us. And, you know, along with anything that's come up over, you know, the course of the last few months. So as we go, yeah, we're able to tap into the resources for our consulting firm, which is very helpful. I don't know if that answered your question.
So I've heard what you said and it made sense to me. However, does that mean that if the workload becomes greater, you could actually reach out to other folks that are not necessarily assigned here, but that work for Four Leaf?
Yeah, so I can, let's say, for instance, that we end up having, we don't need a full-time staff. I can pull somebody to pull one project. And maybe that's a project that Erica needs help with, so she can focus more on one of the ordinances we want to push forward. So if we want to make more of a priority of the ordinances, then I can bring on more staff to help with the projects so that there's more of a balance. Also, these ordinances are a group effort. There's quite the procedure when we're going through these. We do a lot of research. We look at other cities. We go through a couple drafts within our department. And we also talk to other departments, engineering or building and safety, to make sure that we're covering other aspects. And then they go through the attorneys to review. And then it comes back to you guys. So there's quite the process to ensure that we're not only covering everything legally, but we're ensuring that it's also user-friendly, like she was saying, and it's clear and concise.
Right. And so what I'm hearing you say is you can take on this added workload and still maintain the status quo workload and meet the current needs of the community without delaying the needs of the community.
Yeah, I would say yes. The reason that we're able to bring this forward to you now is because we have the addition of 4 or 5 staff members from Four Leaf that are helping us maintain the status quo. As you know, Amber and I are the only city staff planners. Our other staff planners are with Four Leaf, as mentioned. So we've had this list, these 3 things that we've talked about, the one that is about density that we're bringing forward in the next couple of weeks, as well as a list that kind of details out from certain sections, but essentially the entire zoning ordinance needs to be clarified. New things need to be added that don't exist at all. And then our sections that do exist need to be significantly modified to meet state law and also just to be cleared up and be consistent with themselves. So staff has had a big list and we haven't even been able to tackle one until we've gotten this additional staff help. So we're really grateful to have them. And we're at a point where we can start slowly kind of bringing these forward to you on a rolling basis that we're proposing to have these discussions.
Okay. And with this additional work and additional staff, how are you going to stay within budget? I know that this council approved the budget back in June, the end of June. And so can we talk about the cost of this versus what has been approved? Because it seems to me like this is news to me.
Correct. Well, I mean, as I said, some of these codes or state rules are not in our municipal code, and it's making them very inefficient. So there might be additional cost now, but I believe once it's done, it's going to make them more efficient. There's going to be a lot less disgruntled planning customers because it's not always subject to interpretation. It needs to be revised. It's too old is the issue.
So are you going to bring back a request for additional budgeting? Because it sounds to me like this is not
correct. Yeah, the more they dive into it, the more that we realize we need to get this done, and we'll bring that request as part of mid-year.
Okay. And then I guess my final thing is I like the words. I just don't really understand the context. I heard you talk about or say multiple times user-friendly. What does user-friendly mean?
So user-friendly is a broad term. There are several things that make this zoning ordinance not user-friendly. It's confusing where you need to go to find what you need to find. So where is permitted uses hiding? Where is your setbacks hiding? That makes it unuser-friendly for a homeowner. This is not something they do every day. They need to be able to easily go in and find where they need to go. Number two, some of it is written a little awkwardly. And so again, there's room for interpretation in some cases. And in some cases, there's a rule or restriction that doesn't make a lot of sense. Maybe it made sense 15 years ago. It's not really current with today's standards. And so again, a homeowner doesn't understand it at all. So it comes down to writing in plain language, making things easy to find, being consistent throughout. Those kinds of things make it more user-friendly. When we say user-friendly, staff can get into a code and can figure it out, but it's harder for everyone else. So user-friendly really speaks to, we want to make it easier for the public to be able to use this zoning ordinance that we have that really does regulate a lot of things that you do as a homeowner probably need to look at several times in the lifetime of your property. As a business owner, you need to look at it to see whatever it may be that you're trying to do, your business type, if you want to add on, those sorts of things. We're trying to make it easier for everyone as well as ourselves.
Okay, fair enough.
Councilmember Burns, too, also things that contradict state law. You'll have somebody go, well, your code says this, so it's allowed. And then they're going, well, no, because it's so old, there's new state law. And that causes conflict too. And that would make it a lot easier.
Okay, thanks. One last thing. How does this coincide and how is this going to mesh with the redoing of our general plan?
Think that this isn't a fast task that we're asking. Amending the entire zoning ordinance and going into detail with every kind of, we're gonna, if we have these sessions, we're gonna be talking about, what size of trees need to be planted in a new subdivision, what trunks, like we're gonna be talking, that's all the stuff that we have to flesh out during these discussions and write them in a way that is user-friendly, both for staff and for the people who are trying to use these codes. So we are anticipating we're starting it now as opposed to after the general plan update is adopted, but we are anticipating incorporating those ideas in, and I'm not anticipating the actual ordinance to be adopted, the repeal and replace, until after the general plan is actually adopted. I think this process is going to take longer than that.
Perfect. Thank you. I appreciate it. And I support this 100%. Thank you, Mayor.
Thank you.
Mr. Mayor.
Go ahead.
Could I take
Yeah,
one point before
Go
to Tim Burns or Councilmember Burns's point to the budget? I would just add that the planning division itself is budgeted for a city staff of, I believe, 6 or 7, and there's 2. So at least part of the consulting staff that we have, that budget is there to have city staff members that we don't actually have on board at this time. So it isn't fully just an additional consulting budget.
Go ahead and smile now, Tim. I knew it was there. Go
Mr.
ahead,
Mayor, thank you. So the general plan, a bulk of these revisions, overhaul of the zoning ordinance will occur after the general plan is adopted. Do you have any idea when that may occur?
Right now, we are hoping for an adoption in the spring of next year. The admin draft is hopefully going to be released in the next couple of months.
So then we should calendar a joint meeting every month probably till the summer of next year, I would say. Okay.
That's pretty accurate.
Okay.
Yeah, I've heard of something like this taking up to 3 years, but I'm hoping that's not the case. I really don't want it to take 3 years.
Okay. All right. Thank you.
Yeah, I think this sounds like it's going to be addressing a lot of the issues that I get phone calls for. So I support that. Anything to expedite especially our present residents from adding ADUs, all these different things they want to do to their house. So I'm glad that we're finally starting it, and hopefully it doesn't take too long. Because I think that's eventually is going to actually ease up a lot of the stuff that you guys get to deal with. But so thank you guys, and I'm totally support this also.
I'm gonna, go ahead.
So I like your presentation about the concepts in the plan. There's a lot of updating that needs to occur. And I think there's more coming. As you already know, with Senate Bill 6 and AB 2011, there's a lot more coming, and definitely a lot more that needs to be taken into consideration. Having said that, I still want to make sure that, you know, we've asked for a lot of different things in the last year, or at least since I've been in council, about timelines, about transitioning from utilizing outside vendors or contractors to do the work of staff. So I still want that to occur. Like I don't want to continuously have outside vendors come in to do the work that we need to have in-house. So that I would still like that have that plan integrated. A lot of the phone calls that I've received about planning and the plan is the timelines, the delays, the confusion, the variety of different types of information that's provided, additional cost incurred as a result of just not being able to have things understood. And I think even when there's multiple people at every level involved, there's still a lot of confusion and time delays. And if we do look like, one, we need to evaluate the work that's being done. And then two, I want to make sure that we're a cost. So if it does exceed the budget allocation that was approved, then I like for a plan to come back to council. Because I definitely don't want to continue with the model of having an outside contractor do the bulk of the work that we should really have our staff doing.
I'm completely the opposite. I think Board of Ed has done an incredible job. It's helped us catch up. And what you get from some of these different contractors is really expertise from many different jurisdictions that you work with, because you bring in those ideas. You know what's worked well somewhere else, and you come over here and scratch your head and say, why in the world would you be doing this? And the answer all has been in the past, just the way we do it. It's just not acceptable. I think you guys have done an incredible job, staff here, to identify that and know that. And even with that, it's taken us a long time to get to the point where we're at now. So I'm excited to hear it. You brought up a perfect example of the tree issue. We learned from mistakes. We stopped doing it and we turn around and there it is again, because somebody decided, well, that's the way I like it. And then 5 years down the road, we're paying major dollars to repair things. So I like what you're doing. And I think you pointed out very well. I mean, you're using those dollars that have been allocated already to make it happen. So I would like to see us keep going down this path, because I think it's going to get us there much quicker. And again, it brings in more expertise from many different jurisdictions. What I'm concerned about is the delay of the general plan. I have to be very honest and upfront. You know, we were hoping to have this done by summer, and then I heard September, and now I'm hearing spring. So I'm very concerned about that, because we need to get this thing done so we could make these changes, because that has delayed a lot of what we've been talking about. Affordable housing. We keep with the, well, we'll do it later. We'll do it. And I'm not you guys, so make it clear. It's always, it's not a requirement. So we'll fix it later. We don't have to do this. It's not a requirement. We'll fix it later. There's been a tremendous amount of we'll fix it laters that is really destroying our community. And again, this is not you guys. I know where we're coming from on this, but that really makes me worried. It makes me concerned, because it means several more projects are going to try to come through, not implementing all the great things we talked about. And we have to be very careful not to get to that point. Quite frankly, if we're not implementing what we talked about in the general plan, we shouldn't be talking about approving these projects, because it's going to hurt us. And this is why there was this big push to do it right, so we wouldn't have these controversies anymore. But I know there's an effort by several to get more projects approved. And again, we've known it's a disaster for us, and we have to do something about it as quick as possible. Again, I know it's not you guys, but we have to figure out how we're going to do this to get there very, very soon. And you talked about some great ideas, Eva, of workforce housing to really address some of these state hitting us over the head with a hammer that really makes no sense. And we found ways to do it right in our community. And if we can't codify this, we're going to have a situation where we're doing it wrong again. And that's not what we want. We don't want to have 5,000 more single family homes that cost $900,000 each. We want to have a community back where our residents have a place to live. And I know from experience that without doing this type of a change, it's just not going to happen. And I know from past history and experience, it's going to be, well, it's not in the code, so we can't do this, we can't do that. And that's just bad. So just want to be very upfront about that. I need your guys' help. Go ahead.
Yeah, and to that point, I would add that this study session process and then rolling forward, because we do have more staff to help us keep up with the current planning. And so we can get into this long range planning more now, even though it's been long range and on the agenda for a while, but we're anticipating kind of a combo effort. There might be some sections like SB 9, like ADUs, like this minor density change that we're going to bring forward. And us and Placeworks are on the inclusionary as well. So that'll be one you'll see prior to the general plan update itself as well. But I think there'll be some that we discuss in the joint session, which requires so much interplay between different sections that we have now, or so much language change that they're not going to be able to be adopted immediately. But there'll be some that can be adopted individually, and then we'll still do a repeal and replace, but they'll be there again. So we'll be kind of bringing things for discussion where we write them, but we can't quite adopt them until the end. But there'll be things that we'll be bringing that will say, okay, we can adopt this small section now and start implementing this now. So it's going to be kind of a combo effort of updating some sections of the ordinance and actually updating them. And then at the end, we'll have a complete comprehensive ordinance as well from these discussions that we'll adopt. That's the plan.
That's the plan. But again, there's realities of applicants saying, it's not required, I'm not doing it, you're going to approve it. And that's what I'm talking about. We shouldn't be putting ourselves in that situation. We can talk about a lot of things, but if we don't have it written down and we're bringing them forward, we've got nowhere. We haven't learned any lessons. And again, this is not you. And I appreciate everything you guys have done, but we have to find a way to do this like now. So if that means we have a session every day for the next month to do it right.
We can do a session.
Mr. Burns won't be happy about that. So again, thank you guys. And I appreciate what you guys have done, all the expertise you brought to our city. So thank you. Any other questions, comments? Go ahead, sir.
Thank you, Mayor. I actually do have a question for city legal. I've heard what the mayor said, and I've heard the other council members respond, and the commissioner as well. And I'm wondering, is there a sense of urgency of timing where maybe we need to find a way to do this sooner than later? And no, I don't want to go every day on this, but if we need to pull additional resources to make this, put this on a clear path to completion that could coincide with the general plan. It almost feels like the general plan should be the priority, but in the meantime, how do you do two things simultaneously? And so I'm curious what the legal perspective on this is from our attorneys.
Is your concern that the local ordinances are in conflict with the state law?
Yes.
Yeah, so I mean, overall, the biggest concern is that it's confusing because the state law takes precedent. So the fact that they're in conflict, I don't want to say that it doesn't matter because it's confusing. But the state law is going to take precedent. That's the law. So from that perspective, it's not urgent. But
And when you say most of the educated architects or engineers know those state laws that would supersede our code. So it's more the homeowners that would be the issue.
Thanks, Paul. Appreciate it.
Thank you. Yeah, and going back to even your comment of the general plan, these changes, again, my fear is other things are going to be approved. And if we can move forward on what we know is going to happen with the general plan, implement some of those things sooner, as soon as possible, will protect the city and not repeat the same mistakes, and not have the trees in the wrong places. So, thank you. Do we have any speaker cards?
No, Mr. Mayor, we don't.
Okay, well, again, thank you guys. Appreciate it all.
Thank you very much.
Okay, thank you. All right, is there a motion to adjourn?
Actually, Mayor, did we have a consensus to at least have these at least monthly?
Oh,
Sure. Yeah, that's kind of what I wanted to.
So we were thinking the second Thursday of each month. That way council doesn't have to meet twice in the same week. And then we're open to, if you want to do it at 6:30, so you guys have more time to get here. I know that you have day jobs and other things that you have to do. So
Do we know how long approximately the meetings will be?
there shouldn't be the initial length of a workshop like we did earlier today. There may be one item or maybe a case that we bring forward so that we let you guys know, what's going on, what's the latest and the greatest. But for the most part, it should be similar to the planning commission study session that we held. It should be something similar to that. So we're thinking maybe like about an hour and a half or an hour.
Just-
The length will depend on like the complexity of the section we're looking at. And if I understand what you're saying, like we want to move forward. So if we want to move forward faster and there's a section that maybe I would have ordinarily broken into two, then that would just be a longer session. I don't want to be too long because I want you to be able to like do a deep dive and like stay focused on it rather than it becoming a 4-hour meeting and everyone's over it in 2 hours in. So
Yeah.
the hope would be an hour and a half. But if we're trying to move it along, then might go a little bit longer if that's what you wanted to do.
if we're gonna take the time to meet, I would rather we finish what we're doing. Because when you do break it up, there's a tendency like, well, what did we talk about before? They can be complex, but a lot of times staff again has done a really good job of explaining it and presenting the information so we can make that decision. It really comes down to what you bring forward to us. It's here's the facts, here's the changes, or here's what we want to see happen in our community. Here's what's not happening. Here's our recommendation. We go from there. So I like to see it. And if we do it the second Tuesday or Thursday, whatever it works for the council, I'm there. Mr. Burns.
Thank you. So if I understand this correctly, as a study session, the council would actually take no formal action as a result of that. So my follow-up conversation is with city legal. If in fact that's the case, then there'd be no reason that council could not zoom in to see these things in my mind. I mean, if we're not taking any formal action, and for me, candidly, that opens things way up for me. And so it
That's true.
works better for me, and it may work better for others on these two commission and council as well.
So I'm going to jump in here, Jennifer. Okay. So that's actually a great question. We need to look at the scope of I know you don't have AB 361, but the scope of what constitutes a meeting for purposes of the Brown Act. And we can send a memo to council and the commission in that regard and let you know for certain.
Thank you. Appreciate that.
I would agree. I think it's a good recommendation. We did that through the general plan and it worked really well. So I'm open to that recommendation.
If we're asking for dates, Fridays at 5 o'clock work well for me in person. For me, it's just the the lack of notice for this meeting. But if I have notice, I can be here. But Fridays at 5 are just essential.
I would stay with your idea. Was it Thursday? Second Thursday?
So our recommendation was the second Thursday in an attempt to spread out for the planning commission and the council, with the exception of weird months. You might have 2 meetings in a week.
Fridays are difficult. I mean, let's be honest, it's, family dinner time or getaway or whatever, and we're gonna have people missing. So I would prefer the Thursday, second Thursday. But
I'm
again,
fine with the second
majority of
Thursday.
the group.
I've already had to rearrange my music band practice, so anticipation of this.
I find it hard on weekends, and I think we're gonna start missing people.
I won't show up.
Yeah, it's tough.
Yeah, I'm just going.
Well, several of us have other things that we cannot move because we have other things. So Fridays or Saturdays, I know that we're not gonna have agreement. So I think we just have to pick something that really works for all of us.
I think it's hard. We'll poll, we'll do something, get a better idea. on
Well,
dates.
once we find out about zooming in, that's gonna
Yeah.
be huge.
Absolutely.
We will do a poll once we get that answer.
Could I make a question slash potential suggestion? Could we potentially schedule one more, since we have everyone, and then at that one, we could discuss if we want to change the regular occurrence, legal and/or that way we don't have to reconvene, and everybody might know when the next one would be.
Actually, the second Saturday of next month, oh, never mind. It's all right. No.
Yeah,
No, I'm thinking August.
I can tell you again, weekends are just,
Again, I think it's important to hear what our
Seriously.
attorneys say first, because I think that could change all the dynamics.
I agree with you.
And certainly if it comes to doing it every once a Thursday, I'm okay with that. I'll just take the Friday off, and that way I can avoid the commute. So.
I'll work with Mary and we'll get
Okay.
that answer
you.
as soon as possible and get that poll out there as soon as possible.
Thank you. Any other questions, comments? All right, is there a motion to adjourn?
Move.
The motion, is there a second?
I'll second.
Motion second, all in favor?
Aye.
Yes, I. Motion carries. Thank you very much.
Thank you.